Hello everyone, I'm Rowan, a final year law student here at the University of Cambridge, and I'm very pleased to be joined in the faculty's moot court room today by Dr. Raffael Fasel, Assistant Professor of Public Law here at the University, a Fellow of Jesus College, Cambridge, and crucially for today, the co-director and co-founder of the Cambridge Centre for Animal Rights Law. Thank you for joining me, Raffael.
Thank you very much for having me, Rowan.
It's a pleasure. For a start, would you mind telling us a bit more about what you teach and research here at the university?
Sure, yeah. I teach a number of different public law subjects. So I teach constitutional law, I teach human rights law, I teach advanced public law and legislation. But most importantly, for the sake of our conversation, I also teach a paper called Animal Rights Law together with a colleague. My research is in the area of public law as well. So I conduct research on animal rights law, how it's connected to human rights law, for instance, but also work on constitution-making processes more generally.
Great. And you were also the co-founder of the Cambridge Centre for Animal Rights Law. Would you mind telling us a bit more about that?
Yeah, that's right. So that's a centre that we created in 2019. It's an independent charity. We're an educational organisation, a centre of competence, really, for the study of fundamental rights for animals. What would it mean exactly to give rights to animals, and to what extent maybe do we already have rights for animals out there? We have a whole range of different events that we do. We organise a biennial conference that sees people from all around the world come to Cambridge to learn about new developments in animal rights law. We have a law lectures workshop where we sit down with people who want to teach animal rights law. We share our materials with them, our slides, our syllabus, and they then develop their own animal rights law courses. We have opportunities for people who are researchers in their own institutions to come to Cambridge as visiting researchers, visiting fellows, conduct their research here. And something that we want to maybe talk about later as well is we have an essay competition for university students, but also secondary school students, where they can engage with an animal rights topic maybe for the first time.
Yeah, and I'm sure we'll come back to that later in the conversation. But for now, taking it right back to the very start, given that animal rights law is a relatively novel area of the law, how did you first gain an interest in it?
Yeah, so I personally became interested, I think, because I grew up in a family that was always surrounded by lots of animals. So we weren't farmers, but we had lots of companion animals at home. So at one point, I think we had not only cats and dogs, but we even had ducks and sheep as, sort of animals somewhere around the house. And that introduced me very early on to the idea that these animals have their own personalities, they're individuals. And they're really fascinating, for their own sakes, and not just for what they can do for us. But to the idea of animal rights law, I was really only introduced later on when I was a law student back home in Switzerland. And I remember sitting in this class. It was a sort of late Monday evening, first year law of the law degree, and we had a class taught by this eminent professor, and he introduced us to the fundamental concepts of the legal system. And one question that he asked still sort of resonates with me today. And it was, why does the legal system treat animals as things, right? Legally speaking, animals are little different from tables and bicycles and this laptop and this, glass. They're essentially things as far as the law is concerned. But if we think of corporations, for instance, they're treated as legal persons, just as you and I are legal persons under the law. So I thought that was really, quite paradoxical to learn about this, that living, breathing, animate creatures like animals are treated pretty much the same way as an inanimate object like a laptop or a bike or a table. So that's why I started writing papers whenever I could, trying to investigate that question, and ultimately coming here to Cambridge to do my PhD on that very, very topic of animal rights law. So that's my personal story. I'm sure all academics have their personal motivations for what they do, but this is mine. So we spoke a bit about my journey, Rowan, but I'd love to hear more about you. How did you end up in Cambridge?
Well, I'm in my final year now, and it seems like a very long time ago. Time has flown. But when I was in sort of the end of my GCSEs and the start of my A-levels, so about 16, 17, I was thinking, what shall I do next? And to be honest, I was stuck. I really liked essay-based subjects, so history and politics and different things like that, but I'm not sure that I really found any one of those engaging enough to study for 3 years. Then I stumbled across law as a sort of mix between the two. I really like how it brings in current affairs, and I thought, okay, let's give it a shot. So I visited Cambridge through the Cambridge Sixth Form Law Conference, which is a great initiative by the faculty as well. And that really gave me an opportunity to see what it would be like to study law here. And thankfully I made it off the back of that. So yes, I'd encourage anyone who wants to do law to reach out. The faculty has lots of good resources, as well as other universities and different organisations. But definitely it's just about trying to gauge as much experience as you can before committing 3 years and maybe your whole life to the law. So from writing your PhD on animal rights law to now running a full undergraduate course on animal rights law on the Cambridge Law degree, how has that been? And I imagine you're very pleased with the progress so far.
Yeah, it's been great fun to teach it, I have to say. So some backstory to that. So I was fortunate enough to do a master's in the States before coming here, and the United States, although the animal welfare laws on the ground aren't actually quite as robust as they are maybe in the UK, the universities there offer a bit more by way of animal law than we find in the UK and in other parts of Europe. So there I was the co-chair of an animal law reading group, and I realized that you can actually do a lot offering animal law, maybe, talk series or courses yourself, rather than just maybe taking a paper as a student when you have the opportunity. So I wanted to do more. And when I came here and saw that nothing yet is being offered in the animal law space, I created a speaker series. So I invited, together with a colleague, I invited experts from all around the world to come to Cambridge, speak to us about sort of their recent research on animals, broadly speaking, whether it's maybe a new philosophical theory or maybe a vet sharing with us their experience from, treating animals in practice. A very wide spectrum of people presenting their ideas to us. But then I realized that a bit more should be done. And in fact, it was who is now my great colleague here at Cambridge, Sean Butler, who sent me an email out of the blue saying whether I'd want to teach a course on animal rights law. And it's something I've been thinking about before, but he really sort of, had this idea and came to me with it. He's a fellow at St. Edmund's College. As it turned out, I had to Google him. I didn't know him at all. And he turns out had no prior exposure to animal rights law. He was an IP lawyer, a Roman lawyer. He taught Roman law to many students, but just became intrigued by animal rights law and this paradigm-changing nature, this almost revolutionary notion of going beyond just humans having rights and giving some rights to non-humans as well. So he was really intrigued by this, and we said, yes, let's do this. Let's create this course together. We then realized we'd already missed the deadline for offering a course. So we offered the course on an optional non-credit basis. We just basically booked a room in the law faculty, and we were fortunate enough to have lots of people come along, even though they couldn't get credits for it. And then after 2 years, we then became an official course of the undergraduate law degree here at Cambridge. So third-year law students such as yourself can now take animal rights law as part of their degree. And I'm happy to say, modesty forbids, but it's, I think, the most popular half paper. So it's an optional paper, but it's really quite popular with students, which is great.
Great, and that's really reassuring, I suppose, for the area of the law as a whole. And a key part of the teaching of that course is your textbook in animal rights law that you've co-written. Would you mind telling us a bit more about that?
Yeah, so when we started teaching the course, we said, okay, so let's, use whatever the textbook is in this space. So again, we Googled and we found that there is no textbook in this space. There are books in specific jurisdictions. So you might find a book, Animal Law in the US or Animal Law in Australia. But these books are very much focused on the animal protection laws on the ground. And we can talk more about this in a moment. What's the difference between animal rights law and animal protection laws? And they're very specific to that country. They don't sort of branch out and look at other jurisdictions as well. So we felt that it was necessary to write our own book, really. And we just thought, yeah, there's a real gap here, a need for a book that is global in its approach and focuses on animal rights law rather than just animal protection law or what's sometimes called animal welfare law. So we wrote the book. I think it took us maybe 2 years to write it. And thankfully, the publisher agreed that, yes, there's a real gap here and it's been selling quite well. So we're currently working on a second edition. It's going to look into rights of nature as well and how that's connected to animal rights. And it's been translated into Spanish as well. So it just came out in Spanish. And we're working on a French translation as well at the moment.
Great. And I suppose those translations go to the sort of cross-jurisdictional nature of animal rights law as an early area of law. And that's quite rare that you get to explore law internationally, I suppose.
I think it's exactly right. And as we can elaborate in our conversation, there are cases from around the world that also draw from one another. So you see maybe a judge, giving a ruling in, I don't know, Ecuador, and they draw on what's happened in Pakistan before. So it is really an international field, hence the global perspective.
Great. So let's get into the real core of the discussion, I suppose. And I'll start with maybe the impossible question, Raffael. Do animals have rights?
So the simple and short answer is no, they don't have rights. The longer answer is more complicated. So why is the short answer no? Animals don't currently have rights in most places. We can talk about the really exciting exceptions, but for now, let's focus on most places. They lack rights of the kind that humans have, right? So we can call them maybe fundamental rights or thick rights. They're the rights that people are familiar with. Our viewers will be familiar with something like the right to life, the right to bodily integrity, not to be tortured, family life, for instance. These are rights that protect our most fundamental interests in really rigorous ways. They're very hard to interfere with, these rights. Animals, for the most part, currently lack rights of that nature. What animals do have in quite a lot of countries is they have animal protection laws that apply to them, right? So now we can sort of explore that distinction a bit more that we flagged earlier. So around 2/3 of all countries have some kind of law that protects an animal. Now, these laws can be quite sort of focused just on prohibiting certain behavior. For instance, maybe they prohibit wanton cruelty towards an animal, in which case they're called anti-cruelty laws. Around a third of countries have anti-cruelty laws. Another third of countries, and that's where the UK comes in, have more positive requirements as to how we should treat animals, not just behavior that we are not allowed to show towards animals, like treating them cruelly, but also maybe giving them, the food they require, providing them with, the necessary sort of space that they need, caring for the animal, in other words. So another third have that kind of, protection. So 2/3 have it, and then 1/3 of countries just don't have any protection laws for animals at all. But these laws, you can say they're maybe giving animals some kind of thin right or minimal right. In what sense? Well, they impose duties on humans. We have a duty not to, treat an animal with wanton cruelty. You can say the animal now has a right not to be treated wantonly, cruelly. But it's very thin, isn't it? Because it doesn't give the animal a right to bodily integrity. As long as the suffering is considered necessary or not wanton cruelty, you're fine to go ahead with it, right? So you're not actually protecting the animal's most fundamental interest. So in that sense, we can say animals lack the kinds of rights that we know from the human rights context, even though maybe in a more minimal, thin sense, they have rights and certain protections apply to them.
Yeah, and on that, is there a view that these thin rights, these animal welfare laws, can serve as a useful stepping stone to developing maybe a full, thicker system of animal rights law, or perhaps to the contrary, have they entrenched views that we've done enough for animals now and that animals are sufficiently protected?
Yeah, this is the £1 million question in the literature at the moment. So there are, sort of diverging views on this, and I'm not quite sure, to be honest, where I fall on this issue. So those who are skeptical of welfare laws serving as a stepping stone, what they say is, well, welfare laws, they accept as a premise that we can use and kill animals for our purposes. We just need to do so humanely, right? So we need to follow the animal protection laws that are in place, but as long as we do so, we can still use animals for food, entertainment, what have you. So these laws, the critics say, they're not questioning the premise that we can use animals as resources effectively. And therefore, we can never get to a place where animals have rights that protect their interests for their own sake, rather than just because they're instrumentally useful for us. So it's an obstacle rather than a stepping stone, they believe. But on the other hand, we have, I think, also the quite plausible argument that, change happens incrementally. So if you're not building, on sometimes, small successes and small reforms in the law, you're never going to get to that ideal state where, animals have rights. And indeed, there's some interesting recent research by a colleague at Denver Law School, Justin Marceau, and his colleagues, showing that people who are confronted with information that says that certain animals now have more welfare protections, these people also then tend to be more open to granting those animals certain rights. So it does look as though, at least psychologically, maybe welfare can be a stepping stone to rights. But ultimately, I think it's an empirical question and we just need more data on it.
Yeah, and I suppose looking further afield from the UK, where we have robust but limited welfare laws, are there any examples internationally that are more progressive or of thicker laws that you could tell us about?
Yes, so there's certainly a lot of exciting developments that are happening. So one really interesting case is, what we're seeing in the United States. So we can talk about Happy, for instance, Happy the elephant. So who's Happy? Happy is an Asian elephant. She's 56 years old. She lives in the Bronx Zoo in New York, but she was probably born in the wild, probably in Thailand, and was then sold to a zoo in the US and now ended up in New York. She doesn't have a companion anymore. She used to have one called Grumpy, but Grumpy passed away. Now it's just Happy in her 1 acre enclosure in New York. That's quite striking for anyone who knows elephants, of our viewers, because elephants are incredibly social animals, so they live in herds rather than isolated on their own. They're not going to flourish on their own. And they can roam up to 400 square kilometers in the wild. Compare that to the 1 acre enclosure. So what's happened is an organization called the Non-Human Rights Project, that's a US sort of based civil rights NGO. They've brought a habeas corpus case on behalf of Happy. And I should say that I'm on the board of the NHRP, just for transparency's sake, but I wasn't at the time when the case was brought. So what is habeas corpus for our viewers who are not familiar with this? So this is a really venerable common law instrument that we also find in some other legal systems, but it's primarily a common law instrument that allows, say, you, Rowan, to go to a judge and say, I think that, say, Raffael is being held captive illegally. Please, judge, look into the captivity of Raffael. Someone's taken Raffael. They shouldn't have done so. Make sure that Raffael is freed or moved somewhere else, right? Historically, this writ of habeas corpus, this venerable writ, was initially just, applied to white property owning men, but it was gradually extended to other groups of human beings. So in the famous case of Somerset versus Stewart, handed down by Lord Mansfield here in the UK, it was extended to slaves as well. Later on, women became beneficiaries of habeas corpus as well, and children as well. Now, you can see where this is going. The Non-Human Rights Project was arguing, well, the logic of habeas corpus is to protect autonomous beings when they're being held captive illegally. And we think that elephants are autonomous beings as well. Here are some, studies by experts showing that they are indeed autonomous beings. Now, judge, please make sure that Happy isn't freed to, roam the streets of New York, but moved to a large elephant sanctuary in the United States. The judges disagreed with the Non-Human Rights Project, so they decided against Happy in a 2022 decision by New York's highest court, the Court of Appeals. But what's striking about this is that it's still a victory to some degree, because 2 of the 5 judges, or 2 of the 7 judges, I should say, it was a 5-2 decision, they dissented very strongly and very powerfully, saying that an animal like Happy does indeed deserve habeas corpus protection and should have been moved to a sanctuary. So in the grand scheme of things, this is really historic. This is the first time that 2 really eminent judges in New York have said, yes, an animal should have certain thick fundamental rights, such as, bodily liberty, and be moved to a sanctuary.
Yeah, so definitely a step forward to an extent. The majority in Happy's case, the 5 judges, relied partly on an argument that they could not award animals thick rights because animals did not have the ability to reciprocate social duties or legal duties, which is sometimes seen as a precursor to right holding. What do you make of such an argument?
Not much. I don't think it's a very strong argument, to be honest. And I'll tell you why. I think there's two main reasons why it's a rather weak argument that the majority here made, and before a different court as well in New York. Now, the first one is, so the argument goes, you can only have a right if you can reciprocate a duty, right? So if you can give back as it were. And because animals cannot have duties, because they can have, reciprocate duties, they cannot have rights. That's the logic of the argument. The problem with this argument is that there are a lot of human beings who, for whatever reason, are not able to reciprocate duties either. So, take my kids. I have twins at home. They're, 1 year old. They cannot reciprocate duties. Hopefully at some point they can, but currently they can't. Still, they have rights. In fact, it is especially vulnerable humans like them who need those rights the most. Right to life, right to bodily integrity, all of that. And there are other human beings, of course, who, fall in that category as well. If you think of people maybe in a permanent coma, for instance, persons who have severe mental disabilities, they too may have some restrictions as far as how they can reciprocate duties, but it's precisely them who need the rights the most. So the court here, I think, is well-intentioned. It's trying to preserve human rights, but it's doing so with an argument that I think, risks watering down the rights of the humans who need those rights the most. So that's one reason for being very skeptical of this, social duties-based argument. The second reason is it ignores the fact that many animals, in fact, do reciprocate duties. So, maybe our viewers at home, they may have pets. They will be, sort of familiar with maybe their dogs respecting certain rules in the house as to maybe when to, beg for food, for instance, or when to try to, go out for a walk. There are certain norms that are established in communities that animals like us, but also non-human animals, learn to respect, at least to some degree. And, research shows in particular how complex those social norms can be in, species like elephants, for instance, or chimpanzees or others as well. So it's not true that animals don't reciprocate duties, even if perhaps not in a legal sense.
Yeah. So in spite of that argument, I suppose Happy's case was a really strong reason to be optimistic in that it took a step forward, particularly in the judgment of the dissenters. Perhaps even a greater reason to be optimistic was found in the more recent case of Estrelita in Ecuador. Could you tell us a bit more about that case as well?
Yeah, no, it's a fascinating case, and it was a successful case. So here, actually, the animal won. So who is Estrelita, the animal here at stake in this case? So Estrelita was a woolly monkey. It's a type of monkey that's a wild species in Ecuador. Despite being a wild species, she was kept as a pet by a private individual. The authorities got wind of that. They came in and seized Estrelita, and they brought her to a zoo, not to keep her there permanently, but to sort of, check her medical condition, basically. After a month, though, Estrelita unfortunately passed away, and the owner brought a habeas corpus petition that we now know what it is, not knowing that Estrelita had already died. This case reached the Constitutional Court, so the highest court of the land, and they basically said, look, let's ignore habeas corpus for now because Estrelita's passed away, but this is a fascinating case that we still want to deal with because we in Ecuador have this amazing thing in the Constitution called Article 83, which protects the rights of nature, right? So not many constitutions have it, but some limited constitutions protect rights of nature explicitly. And the question they wanted to answer through the Estrelita case was whether rights of nature only applies to collectives, i.e. maybe an ecosystem or an endangered species, or individual animals as well, right? And, thankfully for Estrelita and animal rights lawyers, who are, really fascinated about this development, the court said that individual wild animals fall under rights of nature as well. So individual wild animals have rights now under the Ecuadorian constitutional protection of rights of nature. So which rights, are we talking about here? The right to life, for instance, the right to, move freely in their habitats, the rights not to be hunted down, poached, for instance. What's not so clear in the decision is where domestic and domesticated animals fall here, so companion animals, farmed animals. It's unclear what the decision says. It seems to be focused just on wild animals and maybe doesn't give rights to domesticated animals. But still a sort of significant victory and really interesting too because it connects the question of nature with animals as well.
Yeah, thank you. And I'm sure the hope is that there'll be further litigation in different countries and that this phenomenon, I suppose, will spread across the world. Now, moving from what things are like now to maybe what they should be. In your view, Raphael, which animals should have rights?
Yes, so it may be surprising to you, but I haven't really thought about this question so much myself yet. It's a massive question, and it will need a lot of people working on it. Not least because there's so many different kinds of animals, so many different individuals, so many different species. Now, I think where we will start and where most people are starting is sentience. So the capacity to feel, right? To feel negative things like pain, for instance, but also positive emotions, joy, happiness, and others as well. Most scholars in the field assume that, being sentient is at least a necessary condition for having certain rights. So animals that aren't sentient for the moment wouldn't be considered potential rights holders. But then, of course, there's so many different species that are sentient. What do you do with them? And we're probably going to have to find ways of distributing rights in accordance with the interests of those animals. So we were talking about elephants earlier. Elephants, as we said, are very social animals. They live in herds. So an elephant probably has an interest in something like a right to family life, right? But take maybe a snow leopard. Snow leopards live very isolated lives. They rarely, if ever, meet unless just, for mating purposes. Probably they don't have an interest in a right to family life. So that's just to give you an idea of the kinds of, calculations and the kinds of, considerations we will have to take into account to distribute rights.
Yeah, and on that, I suppose, in terms of the disparity between different species, I imagine on a practical level, jurisdictions would want to craft perhaps a single unified body of legislation to protect animal rights if this ever happened. Have there been any attempts to do that so far, and how have they gone?
Yeah, there have. So there's a really interesting proposal that's been put forward in Finland. So there's a group called the Finnish Animal Rights Lawyers Society. They've drafted a Bill of Rights for animals that they want to include in the Finnish constitution, and it's been debated in the Finnish parliament, in fact. So it's basically a new chapter for the Finnish constitution. They have one that gives rights to humans, and now they want to add another chapter, rights for animals. And they tackle exactly the problem that you mentioned. And the way they do it is by sort of splitting, but also grouping animals together where it makes sense. So the splitting, for instance, happens where there are differences between different types of animals. So for instance, the chapter has a section on rights for wild animals, and it has the section on rights for animals dependent on human care, I think is the phrasing they use. So in the section for wild animals, we find, for instance, a right to have their habitat protected, which we don't find in the chapter or section for animals dependent on human care, because if you're a factory farmed animal, you no longer really have a habitat. You're not a wild animal in that sense. So that's how they split where there are important differences between animals, but they also group animals together where there are overlapping interests. So, whether you're a factory farmed chicken or cow, or I don't know, maybe a reindeer living in the Finnish countryside or wilderness, you're also going to have maybe an interest in remaining alive or an interest in bodily integrity. So both types of species get that right. Okay, so that's how they approach it. They also do something really interesting with sentience, because, I just said some animals aren't sentient, but this line is quite a blurry one and it keeps moving. So in the UK just recently, we decided that lobsters, in fact, and crabs are sentient as well, because the evidence is really there to show that they are. So they're now protected under the Animal Welfare Act. And the Finnish proposal says, look, given that we're not so sure, we should apply a presumption in favor of sentience. So where there's some evidence suggesting that, an animal is sentient, we should probably treat them as sentient and give them some of the rights that the Bill of Rights, presents. And only for not sure at all, and, perhaps there isn't sentience, maybe that's where we can say no.
Yeah, so perhaps that Finnish framework is definitely something that could be used across the world, I suppose. And on that question of which animals should have which rights, your book, More Equal Than Others, outlines your species membership approach. Would you like to tell us a bit more about that and why you think it may be a way forward?
So yes, I'm not sure if it's ultimately the best way forward. I don't want to claim that, but I can tell you why I came up with the idea of the species membership approach. So I developed it because I saw problems in two approaches. The human rights approach that we find among most human rights advocates and the approach that we find in most animal rights people's work. So what's the problem that human rights proponents face? I think they make a really compelling case as to why humans should have rights. But some of them, not all of them, but some of them are hesitant to extend those rights to animals. And they really struggle to come up with, in my view, compelling justifications for refusing to take that step. And they struggle because there are obvious reasons, including evolutionary reasons, for why maybe an elephant or other species, they have interests that are so similar to ours in maybe not, being, subjected to great suffering, that are very hard to deny, why there are these similarities. So that's a problem. And the problem that we see on the other side of animal rights proponents, against not all of them, but some of them, is the way they try to give rights to animals. It's very much focused on the individual animal. So take Happy again. It's all about Happy's individual capacities. How autonomous is Happy as an individual? Now, that may seem logical, but it has a problematic implication because it makes rights dependent on the level of capacities that we find in the individual, right? Why is that a problem? Because it goes against something that we hold dear in human rights law, which is the fact that we don't probe the extent to which an individual has certain capacities. So if we're thinking of autonomy, think again of some of the examples that we talked about earlier, maybe humans with, severe mental disabilities. If it turns out that some of them have less autonomy or no autonomy, it would mean that they don't deserve certain rights which they currently hold as far as human rights practice. That's a very dangerous place to go. We don't want to go there, I think. So to sort of overcome those two problems, I propose to give rights to animals based on their species membership, right? Hence species membership approach. It's giving legal rights, legal personhood, or other legal entitlements, yes, to animals, so going beyond the human species, unlike what a lot of human rights proponents say we should do, but doing so not based on the individual, hence overcoming the problem that some animal rights scholars face as well.
Thank you. One question that our viewers might have, and that I've had as well, is that it's quite easy to see areas where there may be conflicts between the rights of humans and the rights of animals, should they be recognised. What do you think the way forward is in face of those conflicts?
It's a challenging question, I think, and one that we have to, face head on. What we can say confidently is that we're no stranger to conflicts in human rights law. Human rights conflict all the time, as you will know very well, having studied law here at Cambridge. And judges around the world have developed sophisticated tools to resolve conflicts between human rights. Just to give one example, if you have a celebrity, maybe, King Charles, who wants to keep some of his information private, but then there's also an interest maybe in the Daily Mail to publish some of that information, or other newspapers or magazines. We have a right of freedom of press here on the one hand in the media, but also right to privacy, that King Charles has. How do you resolve that conflict? Judges deal with cases like this, conflicts like this, all the time. Probably as we're having this conversation, I'm sure 1,000 judges are currently resolving some kind of rights conflict. That is the way to go as well in conflicts involving potential animal rights as well. So judges will have to apply what's sometimes called a proportionality test that balances different interests as well. It has other tests as well, but the main test is a balancing of interests. So if you're thinking maybe a scientist who wants to conduct an experiment involving an animal, the scientist in principle has the right to do that. There's a right to scientific experimentation. But if animals now have a right maybe to bodily integrity, that now needs to be factored in as well. And we have to ask, okay, so how severe of an infringement is this experiment as far as the animal's interests are concerned? How fundamental are these interests? And by weighing these two different things, a judge will have to come to a conclusion that will ultimately resolve the conflict.
Great, thank you. And looking forward now, finally, how, on a practical level, does animal rights come about, or do systems of animal rights come about?
Yeah, so a really great example to illustrate how that happens is a recent piece of legislation that was passed in Panama. So just 2-3 years ago, 2023, a law was passed on the national level in Panama, granting sea turtles the right to live and move freely in their habitats, so the coastal waters of Panama. That's a striking development because earlier we talked about litigation, so court cases that are being brought. Here, this is an example of a piece of legislation that isn't just proposed, like in the Finnish context, but one that actually passed, right? So how did they accomplish that? Because there's, I think, 5 different, species of sea turtles that now benefit from fake rights to live and move freely in their habitats. At our last conference, actually here in Cambridge in September, we had the MP who spearheaded this law, Gabriel Silva, who talked to us about how exactly he went about doing this and the different kinds of communities he had to engage and work with to make it happen. Because there are a lot of stakeholders that exist when it comes to sea turtles in Panama that I learned about myself, for the first time. It's fascinating. So we have indigenous communities, for instance, that have, for instance, produced jewelry and other things using sea turtle shells. And they've been doing this for centuries, maybe even millennia. We have the fishing industry as well that doesn't so much fish sea turtles, but there's a lot of bycatch sometimes. So the sea turtles can be bycatch as well. And what Gabriel Silva talked to us about is how he engaged the communities. And it's a great example for how this can be accomplished practically. They had indigenous leaders involved as well who talked to the communities. Are there alternative ways, maybe sustainable ways, coconut, for instance, wood to make jewelry as well? They offered workshops to the fishermen and the fishing communities. How can you avoid bycatch of turtles? So by working with the different communities rather than against them, they succeeded in bringing about this really revolutionary law.
Yeah, so definitely reason for optimism if we take a collaborative approach in the future. To wrap things up then, I suppose, I'm sure a lot of our viewers will have found this very interesting and may wish to learn more. Do you have any recommendations for how they can do that?
Yeah. So I would point them maybe to our center because we have lots of different resources for people. So as I mentioned, we have a talk series. All the talks tend to be recorded, so people can just either look it up on YouTube if you type in Cambridge Centre for Animal Rights Law, or on our website, animalrightslaw.org. The link will be in the description as well. You find loads of different talks from amazing experts. I think we have more than 120 talks by now. But also I'd like to flag the essay competition, of course. So every year we run an essay competition for secondary school students, but also university school students. So there's 2 different categories that people can enter. We have prizes of up to £750 for university students, and we give out school prizes for secondary school students. It's an amazing way to immerse yourself in the kinds of questions we've been discussing today, and potentially maybe keep doing this in the future because hopefully people get inspired. But yeah, I would very much encourage students and other people interested in to have a look at all the different things our centre offers.
Yeah, so lots of opportunities to maybe find the next budding animal rights lawyer, the next Raffael, from watching this video. That's about all we have time for, I think. But thank you so much for offering your time, and it's been really, really interesting. And I'm sure the viewers have found it so as well. So thank you very much, Raffael.
Really enjoyed the conversation. Thank you, Rowan.
Thank you.